Nuisance, Chapter 16 from torts. Nuisance is a legal action to redress harm arising from the use of one's property. There are two types of nuisance, including private and public. A private nuisance is a civil wrong. It is the unreasonable, unwarranted, or unlawful use of one's property in a manner that substantially interferes with the enjoyment or use of another individual's property without an actual trespass or physical invasion to the property, to the land. A public nuisance is a criminal wrong. It is an actor's omission that obstructs, damages, or inconveniences the right of the community. A public nuisance, from the restatement section 821B, reads, a public nuisance is an unreasonable interference with a right common to the general public. Circumstances that may sustain a holding that an interference with the public right is unreasonable include the following: A, B, and C. A, whether the conduct involves a significant interference with the public health, the public safety, the public peace, and the public comfort or the public convenience. Or B, whether the conduct is prescribed by statute, ordinance, or administrative regulation. Or C, whether the conduct is of a continuing nature or has produced a permanent or long-lasting effect, and as the actor knows or has reason to know, has a significant effect on the public right. And a private nuisance of the restatement section 851 as reasonable interference with the use or enjoyment of a property interest in land. It does not require physical entrance into the plaintiff's premises. We're reading the definition of tort: a civil wrong other than a breach of contract for which the law provides a remedy. In order to be liable for tort damages, there must be fault. The test for fault is ordinary care under the circumstances. If there, in the Cohen case, we learned that fault isn't going to be blamed on you if you are suddenly stricken with an illness, such as unconsciousness for the first time from like a seizure, epileptic attack, that you did not know you had a likelihood to experience before it came upon you. And that is from the Cohen versus Petty case. In strict liability, a plaintiff may recover for damages sustained by the defendant's blasting activities under strict liability. That's from the Spano case. Abnormally dangerous activities will require strict liability for damages. As a society, who is in the best position to protect? That is the defendant, and the defendants are the ones engaged in the abnormally dangerous activity. Intent requires a volitional act, or the defendant perform the act with substantial certainty that the result will occur. Intent to harm isn't required. It's the intent to bring about bodily conduct that is offensive or harmful, which means, which came from the Wagner versus State of UT. I feel as though what we have right here going on is a complete resuscitation of what I just read. Going into the elements of battery, cases that demonstrate intent, and assault, which I always get wrong, the defendant is liable for the assault if he or she intentionally places plaintiff in the apprehension of imminent offensive or harmful conduct. The elements is that the defendant intends the plaintiff to place the plaintiff in apprehension of what is imminent, and lastly, offensive or harmful conduct. And mere words are not enough. It requires some overt act. False imprisonment, again, unlawful restraint through force or threat of force that confines someone to a bounded area. And all of those lovely cases that demonstrated false imprisonment in the book. Intentional infliction of emotional distress. Defendant acts intentionally or recklessly. And defendant's conduct is extreme and outrageous, and the conduct does indeed cause severe emotional distress to the plaintiff. Those cases were Rubbish, Collectors Association versus Silisnoff, Slocum versus Food Fair Stores, Harris versus Jones, and Taylor versus Valenlunga. And that was third party. Damages. Talks about the three types: nominal, compensatory, and punitive. The trespass to land is any unauthorized entry. Doesn't necessitate damage. A trespass to chattel is intentionally dispossessing another chattel or using or intermeddling with chattel in the possession of another. Conversion is the intentional exercise of dominion or control over a chattel which so seriously interferes with the right of another to control it that the actor may justly be required to pay the other the full value of the chattel. A big distinction is that if the plaintiff can get the chattel back and still use it, then it is a trespass and not conversion. Conversion renders it relatively valueless to the plaintiff. The privileges: consent, self-defense, defense of others, recovery of property, necessity, and justification. I feel as though we talked about all of these. Okay. Consent, express or implied, demonstrated in Hackbart, Moore, and DeMay. Self-defense, we discussed it. Professor's notes make a lot of sense. In defense of others, one can never use deadly force in defense of property, except if it's a burglary or the violence or endangering human life. The recovery of property, kind of like a hot pursuit. You may use reasonable force to recover property immediately after being dispossessed of it. Unnecessary force is not allowed, and the shopkeeper's privilege is there. Necessity, public necessity versus private necessity. In the absence of legislation providing compensation, those whose property was destroyed by an act of public necessity have no right to recover. And Sirocco versus Geary is the right case that I discussed earlier. Private necessity, Vincent versus Lake Erie Transportation. private necessity can be used to defend actions, but generally the plaintiff is, or the defendant's responsible for the damages. For justification, defendant's actions may be justified if the actions taken were reasonable and done to protect others from personal injury or to protect property. Kind of like reasonable protection of others or property. Negligence. In order to be liable for negligence, a person must own a duty to another party, breach the duty, and the negligent actions of the tortfeasor must be the cause of the injury or damage to the plaintiff. So that's the actual definition for you. A duty is reasonable care under the circumstances. A duty would be required if injury is foreseeable. If it's not foreseeable, then and no reasonable person would have known there was a risk, then you probably don't owe a duty to anyone. Talking at length about the risk-utility balancing formula. Causation, in fact, is the but-for test, but for the defendant's negligent actions, the plaintiff would not have been harmed, whereas proximate cause is where the actions that cause an accident are foreseeable, there is liability. And they're like the natural incident consequences of conduct, actions. So damages, risk utility balancing again, costs, I don't know what is meant by this slide. Duty, standard of care, about the reasonable prudent person. I read all of that already. And for professionals, this has been read. Negligence per se has been read. Proof of negligence. There's direct evidence, circumstantial evidence, and res ipsa loquitur. Circumstantial, plaintiff must prove the facts which the jury can infer that the defendant acted unreasonably. But in direct evidence, this is testimony that XYZ actually happened. Circumstantial evidence a little bit further is given as a store owner responsibilities. The defendant must have constructive notice of dangerous conditions within the defendant's store. This is from Joy versus the Great Atlantic and Pacific Tea. And the store owner owes customers a duty to exercise reasonable care in keeping the premises reasonably safe. This is Ortega versus the Kmart Corp. These are the banana peel cases. FYI. If a dangerous condition occurs within a store, the owner is allowed a reasonable time under the circumstances to discover and correct the condition unless it is direct results of the defendant's acts. And that's from Jasco versus FW Woolworth. And this is notice. This is like a notice requirement, being put on notice that a dangerous condition exists in your store. And an example of it is the customer sampling display in H.E. Butt grocery store versus Resendez. 3 burdens of proof for the plaintiff. That's the burden of pleading, the burden of producing enough evidence to avoid summary judgment, and the burden of persuading the trier of fact, which is where res ipsa loquitur comes in. Under certain circumstances, the fact finder is permitted to infer negligent conduct in the absence of evidence of negligent conduct. This came about in Byrne versus Bodle, which is the flour barrel case. Res ipsa loquitur elements. If the plaintiff can show that the defendant had exclusive control over the instrumentality of the harm, the incident is a sort that does not ordinarily occur in the absence of negligent conduct, and the fact finder may conclude that the defendant was negligent. And this is given to us in McDonald versus Perry. In some instances, medical malpractice and expert witness or other evidence that such an event ordinarily did not happen in the presence of negligence is necessary. unless it's obvious. As I said before, a sponge is inside of the person's body after surgery. Exclusive control, it's not about about control so much as it is about identifying the defendant as the responsible culprit. That's from the Cruz versus Daimler Chrysler Motors Corporation. Causation and fact, you have sine qua non. I completely forgot about this. A thing that is absolutely necessary. This is an essential condition, a thing that is absolutely necessary. That's where we get causation and fact from in Latin. And so, translated into English, that's but for test. To hold defendant liable for injury, this would probably be the definition of causation and fact. To hold a defendant liable for injury, the plaintiff must show that the defendant acted negligently, and the defendant's negligent conduct caused the plaintiff's injury. Actually, that's the definition of negligence. But for the defendant's negligent conduct, plaintiff would not have been known. Proof of causation. Where defendant's negligent conduct increases the likelihood of harm, the fact that it might have happened even in the absence of negligent conduct does not break the cause and effect sequence. And that comes from Reynolds versus Texas and Pack-Rye-Co., which I think has to do with not having a lit stairwell. To avoid summary judgment, plaintiff must at least provide information sufficient that a reasonable jury could infer that the allegedly dangerous condition caused the accident. Gentry versus Douglas Hereford Ranch. Mere speculation is just not enough. So the proof of causation has to be not a possibility, but a probable cause. It is not enough for the plaintiff to prove the negligent act might have caused the harm. Plaintiff must prove that the negligent conduct more likely than not was the cause of the harm. This comes from Kramer Services Inc. versus Wilkins. I don't remember that case. Joint and several liability. When separate acts of negligence combine to produce a single injury, each tortfeasor is liable for the full amount even though neither act alone would have caused injury. This comes from Hill versus Edmonds, which I believe would be the fire case I discussed in an earlier recording. Substantial factor. When two causes combine to cause damage and either alone would have caused the damage, both sources are liable, assuming both are negligent, as long as each was a substantial factor in causing the damage. This is from Anderson versus Minneapolis Street. If both contributed to the injury, then both can be held liable. So that's the definition of substantial factor. One of these two cases, Hill versus Edmonds and the other Anderson versus Minneapolis, are probably... One of them might have to do with two people. I don't know the other case besides the fire case. Problems determining which party caused the harm. That's the case where two people are shooting in the direction of, game, and they hit a person across the street. In the case where both defendants had acted negligently, but only one of them caused the plaintiff's injury, the burden of proof on the issue of causation shifts to the defendants. If neither defendant can meet the burden of proof, then both will be held liable. So that's might be joint and several liability still. It doesn't say that. But, yeah, I think they still will both be liable. We're going to read joint and several liability one more time. When separate acts of negligence combine to produce a single injury, A and B are both shooting at C, in C's direction negligently. When separate acts of negligence combine to produce a single injury, each tortfeasor is liable for the full amount, even though neither act alone would have caused the injury. So that doesn't really fit into the shooting case, so the Hill versus Evans case is probably the fire case. Anyway, substantial factor, when two causes combine to cause damage and either alone would have caused the damage, both sources are liable, assuming both are negligent as long as each was a substantial factor in causing the damage. Anderson versus Minneapolis Street. This really isn't the shooting case either. But anyway, if both contributed to the injury, then both can be liable. When two causes combine to cause damage and either alone would have caused the damage, both sources are liable as long as each was a substantial factor in causing the damage. And they're kind of like equally liable under common law. Proximate or legal cause, again, cause and facts and proximate cause. But for the defendant's actions, the damages would not have occurred. And proximate cause, a legal doctrine. So this is where we're getting a little bit deeper into this proximate cause doctrine. Cuts off liability for harm even though the harm was in fact caused by the defendant's conduct, negligently or otherwise, or by the defendant's abnormally dangerous activity or defective product, because it would be unfair or unjust to hold the defendant liable. Proximate cause for unforeseen consequences, right? So defendant is not liable for unforeseen damage caused by the defendant's conduct. Ryan versus New York Central Railroad. Eggshell and thin skull rule is how we refer to a defendant having to take the plaintiff as he finds him, which could be an eggshell plaintiff with a thin skull, and is liable. The defendant takes the plaintiff as he finds him and is liable in damages for aggravation of a pre-existing condition. Defendants are liable for aggravation of pre-existing illnesses or injuries even if they could have foreseen that defendant would be injured in that fashion. Couldn't have foreseen this. And the defendants are liable for all damage they directly cause as long as some harm was foreseeable from their conduct. In re Palomas v. Inverness. An actor's liability is limited to those harms that result from the risks that made the actor's conduct tortious. Overseas tank ship versus Mortstock and engineering. Wagon Mound 1. An actor's liability is limited to those harms that result from the risks that made the actor's conduct tortious. I'm going to read that a third time and then just explain the case because it makes very little sense in stated as a rule of law like this. But the actor's liability is limited to those harms that result, so particular harms that result from the risks that made the actor's conduct tortious. So there has to be like a relationship between the harm experienced and the foreseeable risk that the defendant should have recognized. Since this particular case was weird, I'm going to give the case of a strict liability case where defendant is blasting and nearby there's like a breeder of cats, and the cat mother is so distraught over the blasting that she kills her young, and the defendant's not going to be held liable because he couldn't foresee that happening as a result of the activity that he was involved in. He could be held liable if, like, the shed in which they were being kept falls apart, but because that would be a foreseeable risk of like property damage, structural damage, and he could be held responsible for the damages. that result from the risks that made the actor's conduct tortious in the first place. Reasonably foreseeable risk. The defendant is liable if the type of damage, risk, that was done was reasonably foreseeable to the defendants. So they keep going back to this case of Overseas Tank Ship versus Mort Stock and Engineering Wagon Man 2. In the second case, the defendant was held liable if the type of risk or damage that was done was reasonably foreseeable to the defendant. So in the second case, the plaintiff, who had an interest in a body of water that had an oil spill or some type of a spill of some sort of flammable substance, the plaintiff has an interest in that land, was able to successfully then bring a suit against the defendant when they indicated that the defendant should have known, or it would have been reasonably foreseeable to the defendant, that that substance was flammable at a certain tipping point. And perhaps it wasn't foreseeable to, like, the party that was responsible for the leak, but it was but I suppose they brought it against, like, the engineer, saying that, you know what, maybe not the owner of the ship, but your engineer should have known, something like that. The zone of foreseeable P. Proximate cause extends liability to those whose conduct harms persons within the zone of reasonably foreseeable P. And this is from Paulscraft versus the Long Island Railroad. So, the defendant doesn't know that there's, like, fireworks inside of a package that falls on the tracks. And, let's just say it fell on the tracks because of the defendant's conduct. Well, if the plaintiff was nowhere near the package, but, you know, the fireworks went off when they fell and, you know, launched into something, you know, very far away, and did in fact harm the plaintiff, then the defendant doesn't have to be held liable because of the zone of reasonably foreseeable risk. So first of all, he didn't know there were fireworks in the package, but second of all, even if there was some type of it's not like the plaintiff was standing on the railroad tracks and could have been hit by this package. No, the package had to explode, and this guy just did not know that would happen. So, the fact is, the risk, one would think, would be limited to a certain sphere or zone, and that plaintiff was not in that physical zone. Intervening causes. Oh my god, this is long. Foreseeability. It will not interrupt the causal link if the normal foreseeable consequence flowing naturally from the situation created by the negligent conduct. That's foreseeability. It would not interrupt the causal link if it is a normal foreseeable consequence flowing naturally from the situation created by the negligent conduct. So, ask yourself, is the intervening act a normal foreseeable consequence of the situation created by the defendant's negligence? If so, then there is liability. Extraordinary, unforeseeable, and independent. The acts of a third person that intervene between the defendant's negligent conduct and the plaintiff's injury will interrupt the causal link if the conduct is extraordinary, unfeasible, and independent. Is the intervening act an extraordinary, not foreseeable, independent result far removed from the defendant's conduct? If so, then there is no liability. So is it extraordinary, unforeseeable, and independent harm in relation to the risk? intentional or criminal acts of a third party cut off the liability for the defendant's negligent act. So the defendant in most cases is not responsible for the criminal acts of another, because he can't necessarily predict that some guy's going to walk into the 7-Eleven with a gun and just pistol smack somebody, one of his customers. And he doesn't have to protect that customer because he doesn't really have the ability to do that unless he has like a gun detector to enter into the 7-Eleven. Isn't a bad idea. Acts of God. Only liable if the risk of a force of nature were risks against which the actor should have taken adequate precautions. This comes from the Restatement Third, Section 34, and pretty much exists only in California, that you should expect earthquakes and you can hold someone liable for not retrofitting their place. Same with, like, I don't know, tornadoes in certain areas. Intervening causes, rescuers. A rescuer always foresees risk to himself. So a defendant is liable for injury to rescuers suffered by someone who attempts to rescue another in peril due to the defendant's negligent conduct, say in McCoy versus Suzuki Motor Company. Meaning that, okay, the police officer that responded didn't get hit by, like, a car. And if he did, the person imperiled wouldn't be responsible for the police officer's death because the police officer chose that profession and should expect that type of risk. However, when the police officer asked, or a standby offered to help by holding like flares or something, and the police officer said, sure, you can do that, and then forgot he was there and drove off, and then when he drove off and his like car wasn't there with the sirens, and somebody comes by and just nails the guy with the flares who's not a police officer, then the person imperiled that had the Suzuki, whose car was prone to rolling, are both going to be negligent for the injury suffered by the rescuer who is not a public official, a peace officer. So for the firefighters rule, so I kind of cover them both in one breath. A professional rescuer cannot recover for injuries received while acting in the duty of their jobs. This is part of public policy because they are already being compensated for taking the risks. And what about an off-duty EMT or a nurse? This depends on the jurisdiction. And for medical malpractice, and we're talking intervening causes for rescuers, tortfeasors continue to be liable for medical malpractice committed during the treatment of the plaintiff, who I would think we're talking about suffered from responding to an emergency that was caused by the defendant. Joint tortfeasors, jointly and several liability. Tortfeasors who engage in concerted action that is unreasonable conduct and that injures the plaintiff are both liable. Satisfaction and release. The plaintiff may sue as many defendants as he chooses and may take as many judgments as he chooses, but the plaintiff may recover only one full satisfaction, which is payment for his damages. He can't really double dip. It is limited to what the jury determines the damages are, and sometimes that means the first judgment. Contribution and indemnity. Contribution is when one feeser pays for all of the liability and then sues the other defendant for contribution to contribute his fair share towards the damages Indemnity, unlike contribution, is when a defendant pays the plaintiff. However, the defendant isn't actually responsible. He's just being he was the first guy that this plaintiff got a verdict judgment from. And a lot of cases, this is the insurance company. And then the insurance company goes back to the person who actually caused the accident and says, you're going to indemnify me. You're going to pay me indemnity. So when the insurance company feels that it is not responsible for any of the injury, damages, harm, then he, she, or they are responsible for the full amount. Well, isn't that just the worst definition you ever heard? I'm going to look up indemnity, the actual definition. When you are being held liable as an employer under respondeat superior, you can sue the employee for indemnity and get all of your money back. I just have a hard time believing that, but okay. Satisfaction and release, I know we already read it. And plaintiff may only recover one satisfaction. Now, release isn't actually on this, slide, but the plaintiff may release a defendant. Generally, this is a settlement. A full settlement will release the defendant. Partial settlement doesn't really release him. So I'm going to go get that rule and read that. Indemnity, contribution and indemnity continued. And several other slides yet to read. We need a coffee break.